So you and your spouse have minor kids, and in case both of you were to die, you've named guardians that you'd want to raise your kids, but you forgot about the people you'd never want to raise your kids. Big mistake, and we're gonna fix it. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, let's talk about this classic estate planning mistake parents make by failing to exclude people you do not want to raise your kids. Now, to illustrate this mistake, let me tell you a story of my good friend's sister and sister-in-law. My friend has children, and let's assume he did not name any guardians in his estate plan to begin with. If my friend were to die, then both his sister and his sister-in-law would petition the court to be the guardian of the kids, and the court would have to choose who would be best suited to be guardian in the court's eyes. Now, his sister is in her 20s. She travels a lot, has never been married, has no kids, and is not particularly financially stable since she's only in her 20s. Compare that to the sister-in-law who is in her late 30s, has children, has a steady corporate job, and has been married for a number of years. So just on paper, which is all the court would see if my friend didn't name legal guardians, who do you think the court would appoint to raise my friend's kids? The 20-something-year-old sister or the 30-something-year-old sister-in-law? Probably the sister-in-law, right? I mean, on paper, she seems like the best choice, but the sister-in-law is the last person my friend would want to raise his kids because only my friend knows the truth that while things look good on paper, behind the scenes, the sister-in-law is a big mess. Her marriage is horrible, her kids are on their way to being drug addicts, and the list goes on and on. I mean, in contrast, the sister, who is in her 20s and may not look like the best candidate on paper, is actually an amazing person on the inside, and she's emotionally stable. She's very responsible, and if necessary, she would stop traveling to take care of the children and raise them in the way my friend would want them to be raised. But if legal guardians were not named, then a court would decide who would raise my friend's kids. A court that doesn't know my friend, a court that doesn't know his children, it's simply a judge that just wants to get the case handled and move on to the next case. Now, in that story, the bad outcome was caused by the fact that my friend did not name any guardians of his children at all and left it up to the court to decide. But let's assume my friend named his sister to be the guardian of his kids and also made an exclusion list in his estate plan where my friend specifically listed out the people he stated he would never want to be guardian of his children. That way, just in case my friend died and his 30-something-year-old sister-in-law would bring a legal challenge of his 20-something-year-old sister's guardianship right, now the court can see written proof that it was my friend's intention all along and his will to never allow his sister-in-law to be guardian, which will make it easier for his sister to defend against a guardianship challenge against the sister-in-law. Also, if my friend's sister were to later die herself and my friend had no backup guardians but still explicitly excluded his sister-in-law, then the court would move on to attempting to nominate the next of kin eligible to be guardian and likely never the sister-in-law. So in summary, when you're naming guardians of your minor kids, always remember to make an exclusion list of people that you know you would never want to raise your kids as a backup safety measure in case the guardians you do choose either die or become unable to accept your guardianship nomination for whatever reason. Now, if you're a parent and have minor kids and still haven't picked guardians for your kids, you can learn how to pick the right guardians for your kids by watching my video, How Parents Can Choose the Right Guardians for Their Minor Kids in 4 Easy Steps. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.